So without further ado, thank you very much.
Good morning, ladies and gentlemen. My name is Terry Colbert. I am an attorney. And just to give you a little bit of background on myself, I grew up in the Chicago area, joined the Air Force, was in the Air Force for about 10 years, went to law school, came back here to basically pursue my legal career. And currently I live in Palos Park with my wife, my 5 kids, and my granddaughter. So I have myself, I have a personal vested interest in estate planning, making sure all my affairs are in order. So I do like to help others do the same. My main focus in my practice is estate planning and also real estate. I came today to give you a good overview of estate planning so that you have a good understanding of exactly what estate planning is, what people see it as, and what it really should be. You guys have a handout there that you can kind of follow along with, and I'm going to try to stick to it as best as I can. And before I start, I'd like to ask you all to kind of think about, just very briefly, what you think of when somebody mentions estate planning. Because I find that there's usually a pretty big misconception about exactly what that is. Usually with the younger folks, and as people get older, they get more of an understanding as to exactly what they should be planning for and what they should be doing. But I did look up a few definitions of estate planning online, and this is what I got. Estate planning is the act of preparing for the transfer of a person's wealth and assets after his or her death. And the second one I got, and these are the first two that popped up. Estate planning is when a person or family plans for the transfer of assets and the care of loved ones upon death. So you can see, even on the internet, when you look up estate planning, the focus is on your death, right? But really and truly, that's not what estate planning is about. It's not a truly comprehensive estate plan if all you're doing is deciding where your property goes when you pass away. A better definition of estate planning is to retain control of your properties, give what you have to the persons you love when you want and in the way that you want, planning for your own care, but saving as much as possible for your family when you do pass away, and doing all of this without unnecessary cost or delay. So you can see the process is really more comprehensive, and it really shouldn't have to focus on death. It really should have a focus on planning for your care while you're still alive. That should be your main focus. And then secondarily, you should be planning on what you're going to do with your assets when you do pass away, or what you'd like done with your assets when you pass away, and planning for the care of your loved ones when you're gone. The next page here has an estate planning pyramid, but the slide is kind of blacked out. I just want to mention, it goes along with what I've been saying. The bottom rung of the pyramid, which is the most important, right, because it's the foundation, is really planning for yourself and planning how to take care of yourself while you're still alive. Now that doesn't mean right now, right? Because we can all make decisions for ourselves, we can all do everything for ourselves. But what happens if you get to the point where you can't make decisions for yourself? You become incapacitated for some reason. The example I always use is you get in a car accident and you're in a coma. Who's going to handle your affairs for you? Who's going to make decisions for you if you can't make them for yourself? And then the second rung on that is planning for your family's care and what to do with your assets. And then the top 3 rungs on that pyramid really go towards more high net worth clients, folks who want to plan for tax benefits, folks who want to expand their their estate after they're gone. And there are folks out there that can plan that, right? They want their assets to grow so that kids don't have to. So I'm going to switch gears for just a minute here before we talk about the rest of the documents that would be included in a comprehensive estate plan. And I want to talk about probate, because everybody always talks about probate when you talk about estate planning. And what's the one thing they always tell you? Avoid probate, right? So what exactly is probate, and should you really avoid it? So probate is the legal process where the court allows the administration of a deceased estate. I've been to lots of probate hearings. Basically, you go into court, somebody is appointed the administrator of the estate. The judge approves several things, depending on if there's a will or not. The judge will approve the will, the judge will approve who the beneficiaries are, and then the judge will decide if he needs to oversee everything, or if he can let the independent administrator whom you've appointed or who has stepped up in the case of no will handle everything on their own. But the drawbacks of probate are they can be complicated depending on what's involved, especially if you get one person who is unhappy and wants to make a little bit of trouble for everybody else. And that happens more than you would think, because ultimately, and I have to blame my own profession for this, because ultimately what happens is they go to an attorney, they tell them their woes, right? My sister's getting this, my brother's getting that, I'm getting nothing. And the attorney tells them, well, let's fight it. It'll be paid for out of the estate anyway. So it winds up being fought over in court, and it delays the process. But let's assume that everything goes very smoothly with probate. You have a will, or you don't have a will, but you do have assets, and they need to go through probate. So a case is open, and then it takes probably a few months before you actually get in front of the judge, because the court system is so slow. Then it takes another 6 months, because you've got to give notice to all the creditors by statute. So it takes another 6 months of just sitting and waiting. Then you've got to go back into court again. If there's any real estate that needs to be sold, that process has to be gone through as well. And then finally, about a year to 2 years later, and probably about the quickest probate you're going to get is about 9 months. Everything is wrapped up, and the assets are all dispersed, and the probate is completed. Now, during that time, you are generally paying a lawyer every time he walks in the courtroom, or your estate is. Every time he walks into the courtroom, and every time he speaks to you on the phone, and every time he has to take any action on your behalf. So that's where the cost comes in. So probate, while it's a great method of closing things up, because frankly, if we didn't have probate, we would have a mess, right? Probate basically puts an end to all of the creditors' complaints. It designates who's the owner of all the property of the deceased. And once the probate case is closed, that's it, we're done, our hands are washed. This is how everything moves forward. So it's a great process, but it is time-consuming, and it can be costly to your estate. It can cost thousands and thousands of dollars. And if it does get contentious, it can cost tens of thousands of dollars. So those are some of the drawbacks of probate. And one other thing is there's not a lot of flexibility. You have to do things the way that the statute is laid out and the way that the judge expects them to be done. There are a few upsides to probate. It might be suitable for very small estates, because most of all of the counties here in Illinois have what's called a small estate affidavit that you can file. It's basically like a mini probate, and it closes everything out real quick, and it's a pretty simple process. It may be suitable for estates with many debts, because like I just mentioned, once the probate process is done, and that order closing probate is entered, if you've done everything correctly, nobody can ever make a claim on your estate again. It's closed. So those are a couple of the upsides of probate. But like I mentioned, there are downsides. So should you avoid probate? It's kind of a personal preference. In the long run, if you plan to avoid probate, you will probably save yourself and your estate and your loved ones money, because it does get so expensive to hire attorneys. And again, I do probate, and it's just a matter of the time that's involved and some of the other items that do come up. So let's talk about the documents that are required for a comprehensive estate plan. A plan that takes care of not only what happens to your assets, if something happens, if you pass away, but also who's going to take care of you if you're unable to take care of yourself. So the first document you always hear everybody talk about is a will. And a will is a legal document. This is the document that basically the government, your county, whatever you want to designate, states that you can prepare. There are statutory requirements, certain witnesses and things like that. But if you do have a will, it will be presented in court during probate. The judge will look at it, he will approve it, make sure, basically when he approves it, he's just making sure that you've dotted all your I's and crossed your T's as far as the statute is concerned. And then all of your items, once all your debts are paid, will be distributed according to that will. One other thing that a will does is it establishes who you want to act as guardian of your minor or disabled children. So anybody who has a minor child or a disabled child who's unable to care for themselves really should have a will, at a minimum, because it's going to designate who they want to take care of that child. The court puts a lot of weight on who you designate as a guardian in a will, whereas if there is no guardian designated, it's a whole other court process that's a lot more expensive. And really the judge will scrutinize it a lot more before they place that guardianship and your kids go where you want them to go to if something happens to you. So the will also allows for distribution of assets. We talked about that. You can designate where your assets will go. So when you think about that, that's great, right? That's what I want to do. I want John to get this, I want Sarah to get that, and that's it. That's perfect. But a will does not allow you to put any conditions on your distributions. It doesn't allow you to leave instructions for your final arrangements. So you can't put, you can put funeral arrangements in a will, they cannot be enforced. The judge will not enforce those. You can't, like I said, you can't put any conditions on any of your gifts. So if you state, this money is going to go to John when John graduates college, the judge will scratch that part out and say, the money goes to John, give it to him now. The judge doesn't care what conditions you put on. He only cares about designating your items. Okay? One other thing that people don't think about, it doesn't allow you to leave any property to or for your pet. People laugh about that when I talk about it, but that's actually becoming a pretty big issue nowadays. People who are alone, they've got a pet, they want their pet to be taken care of. They don't want to say, okay, Bob's going to get my dog, and Bob's also going to get 50 grand, so you take care of my dog. No, they want to be able to say, Bob's going to get X amount, and it's for the dog, So just something to think about. So that's a will. It's got its definite benefits in that it allows you to designate who's getting your property, but it has its definite drawbacks as well, because it's very inflexible, and it also has to follow the whole probate process like we talked about. So when you have a will and it designates who gets what, that money's not, when you walk into court and you present that will to the judge, that money's not going to that person that day. If they need that money, there's ways for them to get it, but it's going to take time and it could cost more money. So let's talk about a living trust, because a lot of you have probably heard about living trusts, and a lot of you may be very familiar with what they are, and you may have one in place. Basically, a trust is an arrangement. It's not a court document. It's not a document that's going to have that's mandated by the law. That's part of the probate process. It is separate from the probate process. It's an arrangement under which one person, called a trustee, holds legal title to property for another person, called the beneficiary. Now notice I said there's two people, but when you start your trust, you're the same. You are the trustee and you're the beneficiary. So basically what it is I like to think about it as a box or a bucket that you're carrying around with you. Okay? You still, if you own, everything in your pocket, you've got your wallet, your keys, a pen, a comb, whatever you have in your pocket, it's in your pocket, it's yours, you own it, you have complete control over it. Well, if you take that out of your pocket and you put it in a box or a bucket that you're carrying around with you, nothing's really changed, right? It's still yours, you still own it, you still have complete control over it, you can still do whatever you want with it. That's how you should think of the trust. All it does is it takes it out of your name and puts it in the name of the trust, but you have complete control over that trust while you're alive and able to make decisions. Okay? So it's also called a revocable trust. So a living trust and a revocable trust are the same thing. And it's called revocable because you can change it at any time prior to your death or incapacitation. And that's how you maintain control over all those assets. You can rip the trust up and throw it away and say, no, it's no good. You can sell the house that you've got in trust. You can change who the property is going to go to in the trust. You can do anything you want to change that trust. So what's different from a trust than a will? Well, a trust does not go through probate. In a trust, you designate the successor trustee who's going to follow the rules that you put in that trust once you're unable to make decisions for yourself or once you pass away. So when you're unable to make decisions for yourself, that trustee will be directed to use your trust assets to take care of you. And then when you pass away, the trustee will be designated what to do with your property, just as you would in a will, but with a lot more flexibility. You can basically do anything you want in a trust. You can put any condition you want in a trust. You can divide up your assets in stages. So you want somebody to get the money at 3 different ages. Can't do that in a will. They're going to give it all to whoever it is right away. You can even set up other trusts for people to put your property in when you pass away so that the money's held in trust for them. So it's very, very, very flexible. You can do almost anything that you want. Anything that you can think of, you can put in a trust. And the example that I use, and is not really used much anymore, it's not that common anymore, but it used to be very common, is that, if John doesn't marry a nice Jewish girl, he's not going to get his money. And you could do that in a trust. You can't do that in a will, but you could do it in a trust. Maybe a better one is, if John graduates college, right? Because we all want our kids to go to college nowadays. But that's a trust. And it also can ensure for care for dependents and pets. So instead of just saying, here's money, give it to somebody, and then that person does what they want for the care of someone in a will, you can designate how that money will be distributed. I think I kind of mentioned that already. It also allows for tax planning. Now, tax planning is not really that big of a deal over the last 5-10 years because of the exemptions on the estate tax. Really and truly, a married couple really doesn't have to worry about planning for taxes unless they have over $11.5 million in assets when they pass away. So it's become kind of a niche for very, very wealthy people. But you can do it in a trust. You can plan to avoid ever paying an estate tax.
Terry, what if there's a will in place that's old and then there's a trust that's put in place that's newer? Does one supersede each other that you should keep it updated?
Yeah, definitely. And the trust will supersede the will because the assets that you have are placed in the trust. In other words, the will is not subject to the trust anymore. If, let's say, you had a house and in your will you said, I'm giving my house to so-and-so, but then you have a trust, and the trust says, my house is split between these three people. If that person took that will and tried to probate it, those people with the trust just have to show it in court and say, there's no house to give, the house is in trust. And so that's how that would work. So let's talk about, now we talked about a will, we talked about a trust. Those are the main documents for taking care of your assets and basically directing how your assets are handled. There are several other documents that are really required for a comprehensive estate plan. These are the ones that focus more on you if you become incapacitated. You've got power of attorney for property and power of attorney for health care. There's also a living will, which is basically like, you know, a DNR. HIPAA authorization that allows certain people to view your health care documents so that they can help you make decisions. But let's start with the power of attorney for property. So what does a power of attorney for property do? The power of attorney for property can do anything you want it to. That's what's great about the power of attorney for property. It's very flexible. It can give somebody the broad ability to basically handle all your financial affairs for you if you become unable to handle them yourself. Or if you're like one of my clients, she was just sick and tired. She was 90-something years old. She was sick and tired of handling her affairs. So she said, my daughter's going to handle everything for me from now on. Lucid, completely lucid, she could make decisions for herself. But she said, I just don't want to make the decisions anymore. Let her handle it. I just live here. So I said, okay, let's do that. But the power of attorney for property can be, it can be immediate, meaning you're giving somebody the ability to make decisions for you right now. This person has access to my accounts. This person can do whatever they want. Dangerous, because you are giving that person the ability to have access to all of your accounts right away. And frankly, that can be a greater temptation than some people can handle. So the other option is to make the power of attorney what we call springing, which means it will not go into effect until you are unable to make those decisions for yourself. So once a doctor, or two doctors, or however you want to word it in there, states that you're unable to make decisions for yourself, that power of attorney will go into effect, and those individuals now have the ability to access your accounts. Why do they want to access your accounts? Well, if you're in the hospital in a coma, who's going to pay your mortgage? Who's going to pay your car? Who's going to pay your hospital bills? Who's going to make sure your life insurance is up to date? Who's going to deal with Social Security? Who's going to deal with all the other things that you would need to do when so often you try and call on the phone and they say, well, do you have authorization to speak on that person's behalf? No, then I can't talk to you. Well, they're in a coma. Oh, I have power of attorney, so you can't talk to them. So that's how the power of attorney works. And then the power of attorney for health care is exactly what it sounds like. You know, this gives somebody the ability to make medical decisions for you if you are unable to make them for yourself. And the one important thing about a power of attorney for health care is, and again, the power of attorney for health care is it either becomes effective right away or it becomes effective when you're unable to make those decisions. But the one important thing about a power of attorney for health care is to make sure whoever you designate as your agent knows what you want to do in certain circumstances. Because otherwise they wind up making decisions based upon how they feel instead of based upon how you know, the decisions that you would make. And so it's important to have conversations with whoever you're going to designate as your power of attorney for health care. Illinois changed its statutory power of attorney for health care in, I believe, 2011. They made it very, very comprehensive. It includes language for a living will, which basically states that if you are in a vegetative state and you are unable to make decisions for yourself, and it does not look like you will ever recover, you don't want any extraordinary measures taken to keep you alive. And then the other option is, the length of my life is more important to me than anything, so keep me alive no matter what. So it does give you a couple of options there. So it is a bit more comprehensive than what they are. It also allows you to appoint your HIPAA authorization, so it does allow you to state who can view your medical records. There have been cases where folks have had powers of attorney but no HIPAA authorization, and someone at the hospital is a real stickler, and they said, well, we can't let you view the medical records, so I don't know how you're going to make your decision. So it's always important to make sure you have that HIPAA authorization in place so that people don't run into those HIPAA issues where they can't look at your medical records and talk to your doctor about your condition to really don't know.
Gary, I have a question.
Sure.
So for the healthcare power of attorney, that is pretty much just for whatever is happening now, the information that you're getting now from the doctors and things like that to make a decision for possibly the near future or, you know, that day. The HIPAA is to get information from past healthcare, correct? Am I looking at that correctly or no?
Yes and no. Technically, you're correct, right? Because it doesn't make sense for somebody to have a power of attorney for healthcare and walk into a hospital and the doctor says, I can't talk to you.
Right.
But it has happened. So when I draft an estate plan, I always do both. Even if it's in Illinois, that includes the power of attorney for health, that includes the HIPAA authorization in the document. I always draft a separate HIPAA authorization as well. And I also, and this is just an aside, also several of the documents in Illinois, Illinois only requires one witness to these documents. I always have 2 witnesses signed and I always have them notarized. And you'll think, well, why? That's overkill. Well, just like with the HIPAA authorization, how do you know that you'll be in Illinois when something happens to you? They have other requirements, and while they're supposed to honor, that Illinois, each state is supposed to honor those regulations, sometimes they don't. Sometimes they won't be familiar with it. Banks are horrible for that, just on the financial side. They've got their own way of doing things, and when it doesn't coincide with the law, they don't necessarily care. You can argue with them all day. Listen, I'm a lawyer, I know the law, I can read you the statute. Well, I'm sorry, I can't help you, this is our policy. So I always do both, and I always have other folks sign in that, just in case you're out of state and something happens, just to make sure that everything is covered.
So we, as the person coming in and talking with the attorney, we need to say, because they might not all be like you and hopefully help us as much as you're helping us, so they might not have that HIPAA in there. Or is it a form where it's automatically in there and attorneys just mark it, or do we need to advocate for ourselves and say, hey, I want the power of attorney healthcare and the HIPAA?
Yeah, so if you are dealing with the statutory power of attorney from Illinois, which is what most folks will use, unless you really have some specific things you want to get into, there's going to be a space for the HIPAA authorization that says the following individuals are, able to access my healthcare records, and able to discuss everything with my doctor. And so that would be filled out. If you don't see that, then you should definitely have a separate HIPAA authorization signed so that they can have access to your records.
Is it also like for husband and wife? I mean, I would need authorization to get his, or he would need authorization to get
Yes, under HIPAA, yeah, you still need authorization. So,
did you say that these rules all changed in 2011? So give a trust from prior to 2011, it might not have all that included?
no, the rules didn't change, just the statutory short form power of attorney changed in Illinois. What that means is they basically draft a text of a power of attorney for healthcare and for property, and they put it in the statute so that if you cut and paste that and you put it in a document, it's valid, it's legal because it's right out of the statute. So that changed just for powers of attorney, not for a trust.
So old trusts, we should just check to make sure it still has all that in it.
Old trusts, you should check them, and frankly, I was just going to touch on that. A comprehensive estate plan not only takes into account all of these things, but it also, you should also have it reviewed at a minimum every 5 years. Whenever anything large changes, you should have it reviewed and updated, because when certain things are different in the trust or different in your will and they come up, it can cause issues. Just as an example, I'm leaving my, classic 1955 Chevy to my son John, and I'm leaving $50,000 to my son Greg. Well, then you sell the 55 Chevy. Now, does that $50,000 get divided between Greg and John, or does John now get nothing because the car is gone. So those are things that you need to take into account if you've done that kind of activity. But it should always be reviewed at a minimum every 5 years, frankly. Yes?
Is that a whole new cost involved, or?
So usually a review isn't going to cost you all that much money. Every attorney is different, but if it's just a review and a comprehensive review, it will be charged as a review, not as a whole new drafting of a trust or anything like that. And it's always better, frankly, to go back to the attorney that you had your original documents with, because we're taught as attorneys almost to insist upon redrafting a trust or a will if somebody brings me something that another attorney has drafted. And the idea behind that is because once I've reviewed that other person's document and I've made changes to that person's document, it's essentially my document. So if there are anything wrong in there, sure, that first attorney should have known better, but I should have caught it, right? So it's always better to take your documents back to that first attorney and bring your questions and have them addressed with them. If you don't find that they're doing a good job, maybe it is a better idea to find another attorney and make sure everything's done comprehensively. I know I shoot myself in the foot when I say that, right? But it's true. They're going to be familiar with your case. They're going to be familiar with what you want. They're going to be more familiar with everything that you've already done. So basically, we talked about a comprehensive estate plan and what that really means. It's not really about just about what happens to your assets when you pass away. It's really more about what happens to you, who's going to take care of you while you're alive. Are your assets going to be used to take care of you if you're unable to take care of yourself? And then it's about what happens to everything when you pass away. Okay? I just want to put that out there. A lot of people don't do a whole lot of planning for themselves, and when you get to the point, and another point to make, powers of attorney can only be signed while the person is lucid and able to understand what they're signing. Powers of attorney are only operational while that person is alive. So a power of attorney, while it's an excellent tool and it really can help somebody do a lot for you, it's not an estate plan in and of itself. And it's not a last ditch, I'm going to try and salvage everything so that I can help mom or help dad out. Because I've had plenty of times when folks have called me and said, my mother is suffering from dementia or Alzheimer's and I really need to get a power of attorney. And I say, well, can I sit and have a conversation with her? No, she won't know who you are. Does she know what day it is? No. Does she know who you are? No. She almost doesn't even know who I am. Well, then she can't sign a power of attorney at this point. There's nothing that we can do. And on the flip side of that, my father called me a couple years ago when my uncle passed away. He was not in a good mood. He said, I've called this bank 5 times. I keep telling them I'm his power of attorney, and they keep telling me they don't care. And I said, Dad, that's because he's dead. The power of attorney doesn't matter anymore. He said, oh, that's not true. I said, yes, it is true. By statute. This is your son, the attorney, telling you it doesn't matter anymore. So those are just 2 things to keep in mind on the powers of attorney. There are definite limitations on those powers of attorney. Yes?
Question. As far as power of attorney and running on stuff, when you have like bank accounts, whatever it is you have, should those go in trust or will there be problems?
That is, the question was, if you have bank accounts, should they be put in trust or not? And honestly, that is a personal decision for you to make. I think that the majority of people that I deal with wind up just putting, well, I don't want to say that I deal with, but the majority of people that I see wind up having a child or somebody else on the account with them as a joint owner who basically would take over that account when they pass away. It used to be pretty standard for folks to say, no, just put everything in the trust, name the trust as, open a bank account that is the trust of so-and-so's account, and then you write everything out of the trust. There's two downsides to that. The first downside is some folks may question it. Some folks may question the fact that you're writing a check or you're transferring money from a trust account. The second downside is when people see a trust, and this is, again, related to that. This is why I don't recommend putting vehicles in trust. Because when people see a trust, they automatically think money, even though it's not really necessarily the case in most cases when there is a trust. And, you know, it can make you a target. So, because bank accounts are pay-on-death accounts, meaning when you pass away, you can usually designate a beneficiary for that account as to who can access it and who gets the money. It's really not necessary to put it in the trust and retitle it all into the trust. Investment accounts are different. Those should definitely be titled in the trust, or at the very least, the trust should be named a beneficiary. Bank accounts are kind of the same. If you can name the trust as a beneficiary to that account, you should do it that way, in my opinion. Do you have a question?
I've been told if you have like a 3-year CD, you put it into the trust, you have to wait to maturity because the trust is a living document.
That's accurate. Yeah.
Yeah.
Yes.
Does the trust do anything for liability while you're alive?
No, that's a good question. Basically, a revocable trust, and I get these, like I said before, I deal in real estate, and so I get a lot of calls from investors who say, I want to put my property in a trust because I don't want the liability if somebody gets hurt. Well, you're not really helping yourself because putting your property in trust, you got to think about it from the IRS's perspective. That's why these trusts were created. You still have control of the property, you still can dispose of the property, you're still the owner of that property while you're alive. So it does not protect you from any liability. As long as somebody can figure out that you're still the owner, might make it a little bit harder, put another layer in between it, but usually a revocable living trust is named the so-and-so's, you know, using me as an example, the Terrence M. Fogarty Revocable Living Trust, right? So when somebody goes onto the recorder of deeds office and types in my name, that's going to come up. You know, they're going to know that it was me. So if liability is something that you're trying to avoid, usually it's an LLC or a corporation is a much better avenue. So trust really does not protect you. A revocable trust doesn't protect you.
Are there other trusts that will?
There's what we call an irrevocable trust, and if you think about what a revocable trust is, it means you can change it at any time. It means you own the property, you can do whatever you want with it. An irrevocable trust is basically you disclaiming all of that property, so you don't have any control over it. So in other words, the IRS is telling you can't have it both ways. You either give up all of your ownership of that property, and that's irrevocable, and now you no longer have any liability on that property. Or you say, I do still control that property, and you're going to be held liable for anything that happens to that property. But you know, LLCs and corporations are great ways to limit liability, and they are used in estate planning a lot, especially if you have business and other items, multiple pieces of real estate. An LLC is a great way to limit your liability. Put that real estate in an LLC or a series LLC, and basically it insulates it from you, but you still own the property because you own the LLC. Yeah?
So I have a question. If you end up in a nursing home, can they take your assets then in the trust, or does it have to be like irrevocable?
It would have to be irrevocable. So you're talking about basically planning for Medicaid and things like that, right? That's something that's a little beyond the scope of this talk, because this was more basic. But if you want to try and protect your assets, in other words, you want to make sure that your house goes to your kids, but you know you're going into a nursing home, or your mom's going into a nursing home, or whatever, and they're going to be on Medicare, and they're going to get government assistance to pay for that. Basically, what you need to do is you need to put that property into an irrevocable trust, a trust that you no longer own and you no longer control, or get that property out of your name altogether, and it's got to be done 5 years prior to you needing that government care. So if a lot, and again, this happens to me a lot, people come to me and they say, I'm putting my mom in a nursing home, but we don't want them to take her house, we don't want to have to sell her house for it, we want to put her on, government benefits right away, have them pay for it. Sorry, we can't do it, because the IRS and Medicaid have a 5-year look-back period, and they're going to look back 5 years, and if there was a transfer, they're going to say, sorry, she's, 5 years ago that house was, or 3 years ago, that house was worth $200,000, so technically she's got $200,000 in assets. So disqualified. So yeah, that's another form of estate planning. I don't do a lot of that. I've done it. You have to really have family members that you trust to do that type of estate planning, because it does. Usually it's everything's put into a child's name. I sold a house not too long ago where the son owned everything of the mom's in an irrevocable trust. He owned it for 6 or 7 years, and she did have to move into a nursing home. So everything was done correctly, and they got the proceeds from the house. And the plus side of that is not only that the money is going to go to the heirs, but it's money that's available on the side for other things, right? It's not, so it can be used to help out with other items and other expenses. Yes.
And what's a land trust, since you're off the topic, and I know.
Okay, we'll talk about land trust too.
I've heard that.
So,
because some trusts you have to take the property out of the trust to sell it, some you don't.
Yeah, a land trust, basically, a land trust is one of the older forms of holding property to designate who it's going to go to. A land trust is usually run by a bank. The bank owns the trust, so you set it up through a bank. And basically, it works the same way that a regular trust does, only with regard to this property, though. So you set it up. You are the settlor, so you're the person who's setting up this trust, and you designate who your beneficiaries are and who your remote beneficiaries are. Usually, the folks who set up the land trust are the beneficiaries because it's still their house. They just want to put it in the land trust. And then whoever their heirs are, their children, the trust, whatever they want to leave, is the remote beneficiary. So then if they pass away, that person can sign to sell the property. In my opinion, for the most part, land trusts are unnecessary unless you really want to hide the property. If you want anonymity on your property, purchase it through a land trust, because nowhere on the closing documents is it going to tell you who bought the property. So it's basically, this property went from Bob Johnson to the Chicago Title Land Trust number 8248753. Your name is nowhere on it. Somebody searches for you, they're not going to find that property. The downside to a land trust is that there's yearly maintenance fees. So you're going to pay them, and there's fees for pretty much everything with the land trust. So there's a setup fee, there's yearly maintenance fees, there's a closing fee when you close out the land trust, and there's document drafting fees because you have to pay for them to draft the deed, et cetera, et cetera, et cetera. In my opinion, unless you're worried about anonymity, set up a revocable living trust and keep your property in that revocable living trust. It's going to pass without probate. You don't have to worry about probate. The house is going to go completely outside of probate. And it's a one-time fee. You're paying to set up the trust. You're not paying $150 to a title company or a bank every single year for the next 10, 15, 20 years while you own that property. And you won't get hit with a $500 fee when you go to try and take the property out. Yes, sir?
Yeah, when you said to put the property into a living trust, does that mean you retitle the property into the trust?
Yeah, basically if you own the property, it's just a simple quitclaim deed, and it's titled into the so-and-so's living trust, dated such and such date. And then that's it, that's done. That's one more item that you don't have to worry about having to go through probate.
What happens if there's a mortgage on that property?
Doesn't matter. Doesn't make a difference. The only time that it matters that there's a mortgage and a trust, if the property's held in trust, is if you were going to refinance or if you were going to take out a mortgage. A lot of lenders
Yeah.
I don't know if it's because they don't understand or just because they want to make sure everything's 100% clear, but a lot of lenders will make you take that property out of the trust, put it back in your name, then refinance or take out the mortgage, and then they let you put it back in the trust. They don't care. They just want it in your name when you sign the new mortgage or the new loan documents so that everything is on the up and up and nobody can argue that it was invalid. In my opinion, that's a waste of time and it's a waste of money, but a lot of mortgage companies make you do it. So I did have a client who purchased a house recently who wanted to put it in a trust, but he also indicated to me that he was going to refinance within a year. So I told him, well, don't put it in a trust yet. You're just going to waste another $300 transferring it in and out, retitling the property. Yes?
If I hear you correctly, that current power of attorney and my mom on the checking.
Mm-hmm.
So she passes and there's money in that account. I'm not entitled to it.
Are you power of attorney or are you a joint account?
I'm a power of attorney,
Okay,
both health and property.
okay. So that's how you're accessing the account is through the power of attorney. So technically, if she passes away, that power of attorney is no longer valid.
Correct.
Is there a beneficiary designation for the account? It's you.
Yeah, I'm
Then-
the only child.
Then you, well, but are you designated in that with the bank?
That was going to be my next question. I should probably check with the bank.
Yeah, check with the bank. Most of the time, they've got a beneficiary designation form that you can fill out because most bank accounts are, like I said, aside from CDs and things like that, are what we call pay-on-death accounts, like insurance. Where if you pass away, your insurance isn't going through probate. That's getting paid out to whoever it is with the insurance company.
Because one of the, I'm just going to say IRS account is a POD.
Mhm.
And I can't touch that until she
Right.
passes.
Right, yeah, you won't be able to do anything on that until she passes away. Well, you probably could, but there'd probably be pretty big tax liability.
Yes. And you know how much it costs to get a small claim affidavit?
Well, getting the affidavit is free. You can print it online. It's filing it, and it's different in every county. But usually it's just a couple $100 to file the small estate affidavit. And just in case you're wondering, the requirements for a small estate affidavit, which is the affidavit I talked about for the quick probate process for very small estates, you cannot own any real estate, and your assets have to be less than $100,000. If that's the case, you can go to the Cook counties or whatever county, get that small estate affidavit, fill it out, be appointed the administrator, and get access to
Because
those
what I want
assets.
to get it for, the amount is maybe $300. So
Yeah.
I'd be paying a couple hundred to get a small claim affidavit.
Probably, yeah, it would probably cost that much to file it.
Yeah.
Another reason to avoid court, right? Yes.
Yeah, I think I'll just have non-filed paperwork and cash it that way. Okay.
Yes.
So what items do you actually have to show for probate? Or what items are probatable? I mean, we talked about things that avoid probate, but what are the things that you have to list?
So real estate is a big one. If it's not taken care of, that is a big probate red flag because the majority of real estate, nowadays is going to surpass that $100,000 threshold. So you're not going to be able to get rid of it through an affidavit. And basically any other property that you have that's either doesn't have a designated beneficiary. As an example, I had a gentleman recently who had about $3 million in assets. He passed away. The assets were all held in trust except for a $50,000 savings account that he held in his name only with no beneficiary designated. I don't know if he was hiding it from his wife or what, but she found it after he passed away. And we were able to move that via a small estate affidavit, thank God, because it was less than $100,000. And the real estate he owned passed through the trust, so that worked out pretty well. But had that account been for larger than $100,000, obviously we would have had to probate. If there's no will and no trust, everything's got to go through probate. If everything's small enough, and you won't hear a lot of people say this a lot because it's counter to attorneys, but if everything is small enough, and if somebody passes away, they live in a small apartment, they don't have any accounts, they don't have this, they don't have that. Obviously, you're not going to file a probate estate and have to waste the court's time and waste your own money. But if there are any items of value, or there are any items that you just cannot get to, and those come up a lot more than you think. As an example, when my wife's father passed away, he worked for the city of Alabama, and she was his designation on all the accounts, so she got everything that he was entitled to, his last pay, a couple other things, but there was one hitch. He had about $9,000 in overtime pay and vacation pay that was banked, that they said, well, just because you're entitled to his pay, you're not entitled to this. So you're not getting it. So we tried every other avenue that we could. The only avenue to get to that money and to close that account was to open a probate estate. So those items come up a lot. They do. They come up and they kind of throw a monkey wrench into things, and that's why it's better to have a plan. With most trusts, I have my clients also execute a document that states, I hereby place all of my property in trust. That's not going to carry any weight on items that need to have a title, like house or a car, but cars are a simple matter, so we won't worry about cars. It's very easy to transfer a car upon death in Illinois. All you really need is a death certificate and something showing that you're a relative, and you can transfer that over to you. The other item that also accompanies a trust is called a pour-over will. Yes, when you have a trust, you still want to have a will for two reasons. Number one, if you have kids, you want to designate that guardian, or a disabled child, you want to designate that guardian. And the second reason is just in case something gets missed. And here's the way that the will is worded. It basically states, if I missed anything and it didn't go into the trust, put it in my trust and do with it what I would have done in the trust. There is a third reason, but it never happens because we're very particular about how we do this. There's one other statement I put in all my pour-over wills, and it says, if for any reason my trust is deemed invalid by any court anywhere, then I order my executor to create a new trust on the exact same terms as my old trust and ensure that it's valid. So just a safety net, safety net, safety net to make sure that everything is taken care of. And again, that goes a little bit deeper in the planning. Yes?
I have another follow-up question. I noticed that some of the accounts that we have in banks and stuff like that, they have various terms, like POD, TOD, and WROS. Could you tell the difference between those two? Is there any?
So pay on death is basically a beneficiary designation. It's pay on death is basically if I pass away, this person gets whatever's in the account. Transfer on death, TOD, is what it says. It's a transfer. So the account and all of its rights and all of its obligations go to that person. So in the example that was given by the woman sitting next to you, the CD that has a set term, that's going to be, if it has a beneficiary designation, it's going to be a transfer on death because the person who it's transferred to is going to be subject to the same conditions as whoever owned it. But if it's a simple checking account or a simple savings account, it's going to be a POD, a pay on death, because they can access that money whenever they want. So that's really the difference. And the other one was
WROS.
I'm not sure what that stands for.
I think it's right of survivorship or something.
Oh,
like that.
yeah, with rights to survivorship. So basically, you can hold property as joint tenants with rights of survivorship. There's a couple different ways to hold property. For a married couple, the best way to hold property for the home that you live in is tenants by the entirety. What that means is that each of you individually owns 100% of that home. And how that plays out is, and why the law did that is because, let's say Bob and Mary live in this house, they're married. Bob goes out and incurs $50,000 worth of credit card debt. Mary doesn't know about it, she's not on the account. Bob's creditors cannot come in and take that marital asset and strip it right out from under Mary. It's protected because they're tenants by the entirety. So that's what the tenants by the entirety does. Also, obviously, if the house is owned in tenants by the entirety and one of the spouse passes away, well, the other spouse is deemed to own 100% of that house is going to go to the spouse. Now, joint tenancy is pretty much the same, but without the creditor protection. Okay? So joint tenancy with rights of survivorship basically means that the last person to die owns that property free and clear. So you can have 2 people, you can have 3 people, you can have 5 people on a deed or on an account as joint tenants with rights of survivorship. Whoever can outlive the rest of them gets the whole thing. That's basically what that means. Yes? Tenants by the entirety? Yeah. By the entirety, yeah. Yeah, and that's for married couples, and it's just a way of owning real estate that gives you a little bit extra. Yes?
What about gift tax? What's the current amount? Can't we just give it all away without going through any of this?
You cannot. There are yearly amounts set, and I'd actually have to check on those and see if they've changed.
Because it went up quite a bit, didn't it?
Yeah, they've gone up. The state taxes have gone up, and those are more questions that if somebody really wanted to do some gift planning in that, I would talk to an accountant and get an accountant involved as well, because I do not claim to be an accountant or an expert on tax ramifications. I know a good amount, but I'm not certified in it. So. Yes?
Yeah, if an individual figures they can do this pretty much by themselves without using an attorney, is it supposed to be registered somewhere?
It's not really supposed to be registered. That's another good point. And I'll comment on your first part too. Can all this be done without an attorney? Yes. Can it be done correctly without an attorney? Yes. How will you know and when will you know if you did it correctly? When you die.
When you're dead.
When you're dead and you try to use whatever it is that you made. And, Now, if you come to me and I prepare your will and I prepare your trust and you pass away and I screwed up, guess what? I'm going to pay for it. That's why I have liability insurance. So you're protected. Should I say that? No, I don't want people suing me. But the flip side of that is I don't screw up. If you're doing your job, you're doing it right. If you're not, you're going to do everything correctly. So that's one. The second question, where should it be registered? You don't have to register any of these documents. You don't file them anywhere. That's a very good point. The will, you want to keep the documents somewhere where they're going to be readily available, readily found, and you want to let people know that you've got these. Ultimately, you're going to want to present the original documents to court. If you have an original trust, an original will, they need to be presented. You can present copies, but it adds extra steps. Give copies to people that you trust. Give copies to whoever is going to be your administrator so that they have them just in case they need them. Let them know where your documents are. Give copies of your power of attorney to whoever your designated power of attorney, obviously. Give copies of your power of attorney to your doctor. If you frequent a certain healthcare facility, give those documents to the healthcare facility. If you have a power of attorney for property, give it to your bank, give it to whoever else you think might need it. It's always best to plan ahead for that. But the documents are not registered. You don't have to file them somewhere. When you file them, it's public record. So anybody who's curious as to who got your whatever you had, be they just somebody off the street, be they somebody who wants to take advantage of your loved ones, be they a creditor who wants to go after your loved ones because they found a bill that you owe, they can start harassing those people as soon as they look up your court case online. Trusts are not registered with anyone. 99.9% of the time, they're not even presented to a judge or go before anybody because they're basically like a contract. And they're handled really under contract law and according to the statute, the statutory requirements. So everything that you've done in your trust is completely anonymous. Nobody has a right to call your trustee and say, I want to see a copy of that trust, unless they're a beneficiary. What they can do is they can call up your trustee after you pass away and say, I want a copy of that trust. I think I'm a beneficiary. No, you're not. You're not getting a copy of the trust. So it's that's another benefit of having a trust. Yes, sir.
You have to have them notarized if you're doing your own will.
A will does not have to be notarized. It needs to be witnessed by two people. I'm sorry, it does have to be. The will does have to be notarized. It needs to be witnessed by two people and notarized. Yes. And what I do is I take it a step further, and I also have the witness's signatures notarized. You know, technically they should be anyway, but sometimes that's left out. And it's not, you know, their names aren't added in the notary blocks. Yes.
Is there any way to protect your property should one spouse die and the other spouse remarries, to protect the property so that everything doesn't go to the new spouse's heirs?
Yes, definitely. Basically, you can do that best in a trust. Because in that trust, you can designate what's going to happen to that property. So that trust that we talked about, the revocable trust, is revocable until you pass away. Once you pass away, it's no longer revocable. It becomes an irrevocable trust, and so the terms are set. Your spouse can't change it. So if you designate what's going to happen with your portion of all these items in that trust, that protects that. And you can even stipulate that in, you know, a lot of young people will put that in trust and estate plans. If my spouse should remarry, then, you know, et cetera, et cetera, et cetera. And some older folks who have kids from previous marriages get a lot more involved in that trust as well, to designate what's going to go to these kids and what's going to go to these kids, because, you know, the new couple moves in together, they move into the wife's house. Well, the wife paid the mortgage on that house, it's paid off, so shouldn't it go to her heirs and not be split? So, yeah, that's very easy to plan for that with trust.
Is that different than with a will? A will, a new wife or husband can swoop in and then claim everything for themselves so that the heirs from...
No, a will help to protect from that as well, because remember, the property will be divided at the time of the will. Okay? When that really becomes a concern is if there is no estate plan put into place at all. Because when there's no estate plan put into place at all, the spouse is entitled to 50% of everything, and the kids are entitled to 50% of everything. And so you run into a situation where one spouse passes away, they remarry, now that spouse is entitled to half, the other kids are entitled to half, and certain people get cut out.
Right.
So there are ways to protect that. And there can even be times when, you know, the wording in a trust or a will kind of comes around and bites you, because you didn't say it includes children, you know, adopted or after-born children, or you didn't say this part of the will excludes the children that I had previously. So those are all things that are kind of situation specific, but they can definitely be planned for. Yes, sir.
Talking about the trust and stuff like that, who monitors what the operation of the trust to make sure it's done correctly? You say it's not filed with a court or anything, there's no documents anywhere. You know, somebody will come and challenge, you know, I want to see a copy of it. Well, you're not a beneficiary. How does the person know that they're not a beneficiary? You know, who monitors it to make sure it's done properly?
Yeah, it's the trustee's responsibility to ensure that the trust is monitored properly. They have a fiduciary duty to not only, that means a duty to, a monetary duty basically. You got to think about the best interest of the people that you're dealing for, you're dealing on behalf of. And basically they have a duty to both the person who drafted the trust and also to the beneficiaries. So if a trustee, and it's happened, I know it's happened, but if a trustee were to tell a beneficiary, because let's say that trustee is also a beneficiary, that trustee tells the beneficiary, you're not a beneficiary, so I'm not going to give you the trust. If they find out, then they're going to have a very valid lawsuit against that trustee, not only for whatever money that's owed to them, but also for breach of fiduciary duty. But quite frankly, it is the trustee's job to monitor everything. It's important to choose a trustee, a successor trustee that's trustworthy and that will do it correctly. And if somebody really feels, let's say somebody had 2 kids and for some reason the one kid's telling the other one he was cut out of the trust and cut out of the will and he won't share any documents with them, then they file a lawsuit to compel, to view the trust. Those are the nightmare cases that we never want to see. But we do.
Is it better to have 2 trustees on one?
It's better, in my opinion, it's better to have 1 trustee because 2 trustees can make things a little more difficult. Even if you designate that each trustee can act separately, a lot of times they will force them to, a bank or somebody else will force the 2 trustees to sign off on everything. And that's just, it can be a much bigger pain than it seems to be. Especially if the bank requires wet signatures on everything. So I want to see an ink signature. And one trustee lives in California and the other one lives in New York, and now they both have to sign off on everything all the time. So I always tell people you should have 1 trustee, but you should always have a backup trustee as well. Now, one other point too to make that goes back to your question, something that most people don't usually utilize, but you can. If you have a lot of assets or if you're concerned about something going wrong, you can also appoint what's called a trust protector. This is somebody who is not a beneficiary. They are not a trustee. They don't have a fiduciary duty, but they look at the trust and make sure that the terms of the trust are being followed by the trustee. So that is another option. It's not utilized very often except in large cases or in cases where you might think that something's, somebody can take advantage of something. So just another example that there are so many options with trust and so many things that you can do. And pretty much every concern that you can think of has probably already come up at some point and somebody has done anything with trust. Yes?
Okay, now that you've talked us into it, what does it cost?
So
Ballpark. I mean, is this $4 a minute?
No, it's on a case-by-case basis.
Ballpark.
But
2,000, 10,000?
Ballpark, you're probably looking at about $2,500 for a complete trust-based estate plan. That would include a trust, a pour-over will, all the powers of attorney for property, and any changes within a year will be done for free. So if you do decide to do something else. And sometimes that even includes the funding of the trust, so changing the wills, or not the wills, the deeds like we were talking about, having to change things over into that. And just to give you a cost comparison, you get these done, you've got the powers of attorney for property, you've got the powers of attorney for health care, you've paid $2,500. When you walk into an attorney's office and you need to go through probate, they're going to want a $2,500 retainer. That's the standard retainer fee. Now, a retainer is not a payment. A retainer is not, okay, we're done, that's all you're getting charged. $25, this is how much I need just to start the case. So, ultimately, you save a lot more when you do it that way. And one other point to make too, if anyone else ever needs to be appointed a guardian of somebody, so this is the case where we waited too long, mom's really out of it, she can't sign a power of attorney for property, she can't sign a power of attorney for health care, but I need to take care of her and I need to be able to do things on her behalf. Standard retainer for a guardianship, retainer, not cost, is $5,000. Because they do take a lot longer. Yeah, so does anyone else have any other questions? Yes, sir.
I have one. Trustees are generally paid. Is the power of attorney able to draw a payment?
Power of attorney can. You can stipulate that whether or not you want them to be able to in the power of attorney document. Usually they're not. They've got pretty much complete control anyway. But if you want to help exonerate them, if you've got 2 kids that don't really trust each other too much and you're appointing one power of attorney, you can put something in there that says they can be paid. So that when they go and they use your card accidentally at McDonald's one day, the other one doesn't sue them for, for breach of fiduciary duty, because these crazy things happen. Yes, sir.
If you don't have a medical power of attorney or, what happens if you go to the hospital and you don't have one?
So if you go to a hospital and you're unable to make decisions for yourself, the physician on duty will follow the Hippocratic Oath, and he will do everything that he can to care for you. A physician cannot make the decision, Dr. Kevorkian aside, to withhold care for you. So, you know, if you go into cardiac arrest for the 37th time and you don't want to be resuscitated, the doctor has to resuscitate you if you don't have that, because it's their, you know, it's their license. It's what they swore that they would do. So they will do everything they can to keep you alive. Yes.
So back to vegetative state, who decides, like, at what point are you, like, you're not coming out of something, or you're not functional, you know, who doesn't take you off of, like,
Usually it's it's two doctors. It's the attending physician and one other specialist. Generally it's two. And that's in Illinois. That could be different somewhere else, but I think that's pretty standard. Yes.
I got a strange question. Having a house in a trust, my house was, for my residency was questioned for school, sending my child to school. The district said, well, we don't have proof that you live there because it's in a trust. Have you ever seen any other reasons that the trust could cause a problem? They needed me to send a declaration page to prove that I own the trust, that I live at this residency, and that I'm not using some other house as a residency.
Yeah.
That's in a trust, even though the trust is in my last name. But have you ever seen that? I mean, I'm wondering if that could be the case for college or for any other reasons where people misuse the trust or manipulate the trust?
You know, I haven't seen that. And I can tell you from my experience, having 5 kids and, you know, several of them are in their 20s and going through all that stuff, most places will almost never accept just a deed anymore for residency. They always want, you know, 15 different things. And
well, there was. It was the Nitro bill, the Common
Yeah.
bill, the AT&T bill.
Yeah.
It was 4 documents, and then the trust. They said, we still don't know that you live there. Where do you think I live? I'm homeless then. I told them.
That
And I said,
becomes,
homeless, you get to pick your school. So I said, I'm homeless.
yeah. That becomes,
That's what I said. I go, 4 proofs of bills in the house, but the
That
trust
becomes
was
a
not,
kind of
house was in a
specific-
trust. So I didn't know if that would be the case then for college applications or anything, because how would you prove in-state, out-of-state then?
Yeah.
If I ran into this much problems with an elementary school.
I haven't seen it
But this
as
is the
an
first
issue.
year they did it.
Yeah.
They're cracking down on residency.
Where are you at?
This school, the former school district. So I don't know if colleges would start doing, I mean, it was a headache because they asked me like 6 months afterward. They're like, we can't enroll your daughter. We enrolled her in April. They're like, she's not enrolled for August because we don't know that you live here.
Yeah, we need to do the same. We need to prove residency for all my kids every single year. It's
But
really
have you ever
annoying.
seen that with the trust? So the
I have
house is in
not.
trust.
The only issue that I've seen with the trust is we will not refinance your house unless you take it out of the trust, put it in your name, and then put it back into the trust. And frankly, if anybody understood trust, they should allow you to provide the certification of trust document, and which is basically the certification of trust is a document that says this trust has been created. It's been created by me. I own the trust. I own the property. I do what I want with the property. Blah blah
That's what we
blah
had to
blah.
provide. We had
Yeah.
to provide that declaration page saying that we have the trust.
Yeah.
But it was
Did
just-
they accepted that though?
Yeah, but it was annoying because it was like the next day was school starting, and I'm like, seriously? I mean, I contacted the principal. I was like, seriously?
Yeah.
I'm like, four proofs, and then I go, you understand why it's in a trust to protect your child,
Right.
and yet you don't find that valid.
Yeah, no, I haven't seen that as an issue with the school
I didn't know if it was
district.
going to be, any other issues, but it makes sense for the financing
Yeah,
because it's kind of protected, but
right.
I didn't know if there was any other reason. But it's more like they're getting more strict on all the rules for everything.
Yeah, I think so. I think that's probably the case.
Well, Catherine, 2 things. You should have just had them over for dinner.
I know. That was my next one. I went to her room,
And they might not have been educated on the trust. I wasn't until today, so they probably weren't educated and they
oh,
were.
they asked specifically for the declaration of the trust. And I was like, you know what it is then.
Yeah.
People
I have.
scan the system, that's why sure.
They do.
I mean, people
especially in more rural areas, they know all kinds of ways to check and drive, right?
Well, thank you, Terry, for everything. If you guys have any more questions, I've left information. We do offer free consultations. If you have questions about your plan or anything like that, please do give us a call. Our office is near 183rd Wolf in Moreland Park. So I have a brochure about it, and then our information, and then Terry's card. And they also left a little flyer that next month we're going to be hosting a program on healthcare options coming up for 2020, whether there's been some changes in Medicare or whether your individual insurance. So we're going to be holding that in Homer Glen at Front Row. So there's information on that. If you guys think of any more questions or anything, or kind of want to schedule a consultation, you can call our office. My name's Kelly, and then I can set you up with Terry.
And I apologize, I would normally stick around to answer